Welcome back to the Williams Elleby Howard and Easter YouTube channel. I'm Joel and this is Jared, and there's been some significant changes in the way that evidence comes in trials in Georgia, specifically regarding medical bills and what the jury can be told about them and how medical bills are paid and what kind of advice attorneys give to their clients as a whole on the best way to go about getting your medical bills paid after a personal injury. So we're going to dive into that today, because we have other videos that are under the old law that aren't necessarily accurate anymore. So this is the one in 2026 that you're going to want to think about if you have medical bills after a personal injury, whether it's a car wreck or a fall or anything else. So the number one question, and the first thing that we want to answer, probably has the most practical use for car wrecks, and that deals with med pay and hospital bills or medical bills after the wreck, and how that plays into the use of health insurance or liens and any of that kind of stuff. So Jared, you want to get us started with that?
Yeah, so first off, medical payments coverage is something that you would pay for under your own insurance policy that could pay for medical bills when you get into a wreck. There's an interplay between med pay and your health insurance and who pays first, who pays second. Preferably, we would like health insurance to pay first, but hospitals disagree. Hospitals want to get to the medical payments coverage first. And you can run into a problem because the hospital will refuse to bill your health insurance until they figure out whether you have med pay and whether they can get that money. And this is well intentioned by the hospitals trying to use that coverage first, but sometimes things get lost in translation, and you go to the hospital, you're in a wreck, you're trying to figure out what's going on, and you're waiting to hear, did the hospital bill my health insurance? Do I have, a deductible that I have to pay? And you never hear anything. Just call the hospital and they just tell you, oh, we're waiting on med pay. So what's happening is they want to know, do you have med pay? And if so, can they get it? If you have med pay, great. They're going to bill it, it's going to get paid over, and then health insurance will pay next. But where the hiccup can come in sometimes is when you don't have medical payments coverage. So the hospital bills your med pay that you don't have, and they don't hear anything back. So then it just kind of gets lost in the stack of medical billing, and no one ever gets back around to billing health insurance, which creates a problem because most health insurances, private health insurances, have a billing window for timely submission that's 1 year. So if your bill isn't submitted to health insurance within the year, then your health insurance has the ability to deny paying for it. So obviously, that makes it really important that the hospital bill your health insurance. But they're waiting on this med pay letter that never comes. So it's important, if you have an attorney, a good attorney will get involved to help do this. But if not, it's important that you reach out to your medical payments people, reach out to your car insurance and get a letter or even your declarations page that shows that you don't have med pay, and then get it to the billing office at the hospital. That way the hospital can check their box that they've either billed med pay or that you don't have it, and then make sure that it gets billed over to health insurance so that it gets paid.
Yeah, and if you do have med pay and it pays, say you've got $1,000 in med pay, they pay that towards the hospital bill, then stay on the hospital billing department to make sure that they submit the remainder of the bill to your health insurance so that your out-of-pocket expenses are minimized as much as possible.
And one other thing I forgot is, if the hospital has your health insurance information, you do all of these steps, and the hospital still doesn't timely submit it, then practically speaking, the hospital should write that balance off because it is a billing error on their part. They had everything they needed and they failed to get it billed timely. So most health insurance contracts have something in them that say, if the hospital has it, they're aware, they've been through the steps, and they still don't get it billed, that the hospital has to write off the balance and not make you wholly responsible for it.
Yeah. All right, so switching gears to the new evidence rules in Georgia. Georgia used to have what we called the collateral source rule. This meant that if you have health insurance or any other kind of coverage that's going to pay for your medical bills, that if you went to trial in a case, the jury would not know about that. Just like a jury does not know about automobile insurance, or they're not told about it. They should know about it unless they live on another planet, but they're not told about the health insurance or the automobile insurance at trial. Now in Georgia, some of our state leaders thought that it was a good idea to move away from that rule, which prevented the at-fault party from benefiting from the hurt party's responsible actions of getting health insurance and paying for it all these years, to saying, all right, nope, that's now admissible at trial. So if you have a $10,000 hospital bill and your health insurance pays $4,000 on that bill, then the jury will be told that the health insurance paid $4,000 on that bill. So that affects how attorneys are approaching trying cases, at least in the state of Georgia. In some other states, this has been the law forever. But in Georgia, it's a significant change, because when an attorney might be able to say, hey, the medical bills are $200,000, now the defense attorney is going to be able to say, well, that might be the sticker price of the bills, but health insurance only paid $75,000 or $50,000 of that. So the idea is to try to get the jury to only award $50,000 or $75,000 for those medical bills, because that's what health insurance paid. Now, what we may or may not be able to get into at trial are a lot of different things as to why health insurance only paid $50,000 or $75,000 of that bill. Well, it gets into a whole just mirage of stuff dealing with health insurance contracts with the hospital, with the medical provider, how much the injured person has paid in premiums over the years, how much their employer has paid in premiums over the years, just so they get the benefit of that coverage. And should the defendant who caused this wreck get the benefit of the employer or the employee or the injured person paying these thousands and thousands of dollars in health insurance over the years to get this benefit? So that's a question that's going to be presented at jury trials in the state of Georgia from now on, and it really goes into trial strategy. So do we claim medical bills in cases where the medical bills are fairly low? Do we even mention that? Because a lot of times the real damage and the real value, if you will, in a case is the impact that it has on a person's day-to-day life. How do they suffer? How has their life been changed because of this injury, as opposed to the dollars and cents that they have to pay out? But that's one thing that attorneys are really juggling and just wrestling with right now, is what's the best way to approach this? Because in some situations, the jury may say, look, we're not giving the at-fault party and their insurance company the benefit of, the injured person being responsible and getting health insurance that admittedly cost an arm and a leg nowadays just to have it. And in other cases, they may say, well, we're only going to give them what the actual dollars paid are, because the rest we see is excessive. So juries are going to come down on both sides of that, and how attorneys approach that in the state of Georgia is going to vary from case to case. But there's another thing to think about too, is that in certain situations, the health insurance, depending on whether it's really health insurance or whether it's what we call a self-funded ERISA plan, non-insured ERISA plan, that would be controlled by federal law as opposed to Georgia law, whether that insurance or plan has to be paid back. And that's, something people have to think about, Jared.
Yeah, definitely. Because I think, practically speaking, if you have to pay it back, then, that's definitely something that can be claimed in the case. I think trial strategy specific, relying on that is a good way to kind of speak to a jury and explain to them, what the contract says, what's in there, and try to help them understand that ultimately the money does have to be paid back if it is a federally self-funded ERISA plan. That does have to be paid back in full. And some of those, it's kind of a moot point, because some of those pay really well, and it ends up being close to what the medical bill totals are anyway.
Yeah. And another thing, there's this thought process out there where the injured person may say, well, I don't know why my health insurance should have to pay for this anyway, because it wasn't my fault. If Jared causes a wreck with me, why should my health insurance have to pay for something that he did, right? So in those situations, Georgia law says that the jury will still be told about the fact that I have health insurance, even if I decide to treat on a cash payment basis or what we call a lien basis. But some attorneys are taking the approach that, well, you know what, that argument makes sense, and we're going to have our client treat on a lien, meaning they're going to go to a doctor or a medical provider that will not bill as you go to treat, but they will hold that bill until the case is resolved and then be paid back out of the settlement or the judgment or whatever for the full amount of that bill, or some negotiated rate if you're able to negotiate it. And so that could be a very real option in situations where, the attorney and the client feel like, hey, like, this was not our fault. It wasn't our health insurance fault. It was the other person's fault, and they should be responsible for it. That's maybe a viable option. It's a sort of a risky option, because if the case is significant enough and the defense lawyer in the case is astute enough, they may go in and say, okay, well, Blue Cross is the injured person's health insurance. They would have paid this hospital X amount of dollars for all these different CPT codes, and so this is the amount that should be awarded. Some juries may buy that, other juries may not. So what's really happened with the passing of this new law in Georgia is it's created a whole lot of uncertainty as to exactly how or exactly what the best trial strategy is for each individual case, which frankly means that when you're choosing an attorney in a personal injury case, it's going to be very important that you find a law firm and you find an attorney that's going to analyze your specific situation and not treat it like some cookie cutter approach when they have thousands of cases and they do all of them the same, because what works for Jared may not work for Joel in a specific case to maximize the recovery and make sure that all your bills are paid, that you get a fair amount from pain and suffering, and that you walk away at the end of the day from your settlement or your jury trial and your verdict satisfied with the ultimate resolution.
Yeah, and I think it's important as a practical note. We talked a lot about trial strategy, but practical advice for a potential client is, if you call the insurance company, don't let anyone convince you that the jury has to only award you what your health insurance paid. That's what we're hearing out of everyone, and that is not what the law is. The law says that the jury gets to hear about it. It doesn't say that the jury must use that as the measure of damages. So if you're out there on your own trying to handle your case and the insurance company starts citing this new tort reform law and telling you, well, we only have to pay what health insurance has paid, don't fall for that. Also, along the same lines, you don't have to use your health insurance. A lot of times it makes complete sense, like Joel was talking about, but sometimes people have catastrophic health insurance that has a crazy high deductible and a crazy high out-of-pocket max, to where you're spending $5,000 to $10,000 before your health insurance does anything. Mm-hmm. And for a lot of people, that's just not feasible. And you get in a wreck, someone hits you or somebody hits your family member, it shouldn't in the short term cause a financial disaster for you to get treatment. So don't let an insurance company convince you, one, that you have to use your health insurance, or two, that if you do use it, that's all they have to pay is what your health insurance did or would have paid. Maybe they do, but that's up to a jury. And if you have a good lawyer, a good legal team fighting for you, they can help you make the decisions as to what's best for your family and your financial situation, and then make sure that the insurance company is held accountable when the time comes. Yeah,
because quite frankly, insurance companies are dealing in millions and billions of dollars every year, and they can lose sight of the fact that, a $10,000 maximum out-of-pocket amount for a year is just not in the cards for a lot of normal, everyday American families. For some families, it is in the cards, and $10,000, just to have access to the medical insurance payments is not a big deal, but it takes time to sit down and figure that out between the attorney and the client as to what's best for this person in this case, in this situation. And so I guess ultimately it's just a new rule that we all need to be aware of, and people who are injured need to be aware of the fact that there's going to be these laws that can have a dramatic effect on them personally, depending on how they and their attorney approach getting the medical bills paid for moving forward in a case. So anyway, that's the new rule in Georgia as of now. I'm sure it's going to be challenged. We may be back here in 2027 making a new video. But as of right now, that's what we're dealing with. So a lot of uncertainty, but there are strategies that we have in place to try to deal with that, to make sure that it's handled in a way that's best for each one of our clients, and what's right for client might not be right for client B. So we have to make that that decision on an individual basis. But if this video has been helpful to you, we'd appreciate you giving us a thumbs up, hit that like button, hit that subscribe button. Otherwise, we will see you in a couple of weeks with our next video.
As personal injury lawyers, we love what we do, and we're happy to share the experience we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when you're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.